So it's kind of interesting, like for us, like if we are discussing about like AIs or any part of like maybe I'm researching about copyright. So if we discuss about AI or copyright, and generally we will discuss about like China, US, EU, or the UK. So this is generally what we are going to do around the jurisdictions, but we never like have the angles or have the perspective to look at like Nigerians or have the perspective of Africans.
We have in Nigeria a digital transformation strategy that recognizes the utility of AI in achieving certain national objectives, one of which is literacy.
There is concern that using foreign-owned AI platforms, so think, ChatGPT, Copilot, Gemini, Claude, and the likes, using these AI platforms might lead to the exploitation of local student data.
Through the presentation, copyright is presented largely as a kind of constraint on educational access. Copyright also provides incentives for the creation of educational materials or digital learning resources. The Universal Copyright Convention, I was saying, in 1952, then the Berne Convention itself, and later the 1967 Stockholm Protocol to the Berne Convention attempted to introduce some access to copyrighted works for developing countries as well, through mechanisms such as compulsory license.
You can look at the transition Nigeria has had from the NDPR, that's the Nigerian Data Protection Regulation, to the Nigerian Data Protection Act. And we do have a Data Protection Commission in charge of data of everybody.
It's a wonderful initiative.
The Globalsouth network opened new horizons for judicial cooperations.
Globalsouth network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
Ge Chen network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the Globalsouth network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
Dr. Norman Riat, the founder and convener of the Globalsouth network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Riat's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face
in safeguarding the rule of law and constitutionalism.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
This last question is not so easy, a bit complicated.
The Globalsouth network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on a particular importance thanks to Globalsouth network, which allow us to believe in a better world of the rule of law.
Good afternoon, everyone. It is with great pleasure to welcome you to the 26th seminar of Phase 5 of the Globalsouth Network International Interdisciplinary PhD in Progress Seminar Series. Before we begin, I would like to thank Dr. Newman Rehat, lecturer in law at Leicester Law School and founder and chief convener of the Globalsouth Network, for organizing this weekly seminar series and for his continued efforts in bringing together scholars from around the world. My name is Dr. Nkem Itai. I am a lecturer in intellectual property law at the School of Law, University of East Anglia, and at the Faculty of Law, University of Nigeria. My recent social legal research evaluates the complexities of copyright in the film industry of emerging economies, using Nigeria as a case study. Utilizing a multi-perspective approach, I focus on the intersection of copyright law with work and lives of creative practitioners in the film industry. I am also the co-editor of a recent Routledge book, which talks about decolonizing copyright law. On behalf of the Globalsouth Network, I would like to thank all of you for joining us in this session. I am delighted to be chairing today's session. I would also like to extend a particularly warm welcome to our guest speaker, our distinguished discussants, our peer commentator, and all colleagues and participants attending from different institutions and jurisdictions. Our first discussant is Dr. Felipe Romero Moreno, who is an associate professor at Hertfordshire Law School. Dr. Romero Moreno is an expert in information technology law, intellectual property law, and human rights. His research examines the relationship between new and emerging technologies, including generative artificial intelligence and privacy, data protection, intellectual property, freedom of expression, and due process. He has also undertaken research on the transformative implications of generative AI for university teaching and assessment. Our second discussant is Dr. Ge Chen, Associate Professor in Global Media and Information Law of Durham Law School. Dr. Chen's research encompasses free expression, media law, global constitutionalizing, and international copyright law, with particular attention to their constitutional and rule of law dimensions. He is the author of Copyright and International Negotiations, an engine of free expression in China, published by Cambridge University Press. We are equally pleased to welcome Yinkan Lu as today's pair commentator. Yiheng is a doctoral researcher and teaching Associate at Queen Mary University of London. His doctoral research at the Queen Mary Intellectual Property Research Institute examines moral rights in relation to artificial intelligence-generated content. With an academic background encompassing both law and electrical engineering and automation, he brings an especially valuable interdisciplinary perspective to questions concerning artificial intelligence, creativity, and intellectual property. We are also pleased to welcome, last but certainly not the least, in the list of speakers today, our guest speaker. Our guest speaker is Oshobugie Suleiman Irumekhai. Oshobugie is a Nigerian-trained lawyer and a PhD researcher at Western University in London, Ontario, Canada. His doctoral research investigates the relevance of intellectual property rights in facilitating or potentially restricting to AI-driven technologies capable of improving educational outcomes in developing countries. Beyond his doctoral research in intellectual property law, Oshobugie has co-authored scholarly work examining the legal and regulatory frameworks addressing illegal mining, environmental pollution, and corruption in Africa. Let me briefly explain the format of today's seminar. We will begin with Oshobugie, who will first present his research for approximately 25 to 30 minutes. I will provide a 2-minute indication as he approaches the end of his allotted time. We will then invite comments from the two discussants, beginning with Dr. Felipe Romero Moreno and followed by Dr. Ge Chen. Each discussant will have approximately 5 minutes. Yiheng Lu will then offer his observations as a peer commentator, also approximately for 5 minutes. Following these contributions, we will open the discussion to questions and comments from the wider audience. Please use the raise hand function or indicate in the chat if you would like to speak. Alternatively, you can drop questions or comments in the chat box anytime during the session. Oshobugie, it is now my pleasure to invite you to deliver your presentation on artificial intelligence, intellectual property, and the pursuit of quality education in developing countries. You are very welcome, our guest speaker. You have approximately 25 to 30 minutes, and I will let you know when you have 2 minutes remaining. Over to you, Oshobugie.
All right. So I begin with the abstract, which discusses or rather explains how quality education is the building block for individual and societal progress and how it drives sustainable growth and development in society. But across the world, we have different education systems in certain countries that struggle with delivering good quality education to their students, and there are a number of factors or challenges that have been identified which work against this. Recently, with the emergence of AI as a game changer in many fields, scholars have identified AI as a tool that can improve educational outcomes in some of these countries, particularly developing countries. Despite the merits that have been identified or the benefits that have been identified that can accrue from using AI to improve quality education outcomes, there are certain challenges that exist with respect to its deployment, and we find that most particularly in the field of intellectual property rights. One such example has to do with particularly the 3-step test, which might hinder access to educational materials or data needed to train the AI algorithms. Other issues are present in relation to ethical and data privacy matters, but for the purpose of this presentation, I focus mainly on the copyright or intellectual property issues. My research intends to analyze the copyright jurisprudence in Canada, Kenya, and Nigeria. I intend to do this using a doctrinal legal research methodology. And in the course of my research, it's my argument that AI will indeed foster access to quality education and bring about the inclusion that is needed. But to do that, you need to reform the international copyright system, because it acts as a clog in the wheel of educational advancement. I'm going to go with the introduction. I'm going to begin the introduction where I identified education as a driver of economic growth, peace, health, and social participation. It has been found that a year of extra education for women of reproductive age can actually reduce child mortality by 9.5%, which I highlighted in the circle. And then there are major gaps in learning outcomes that are tied to low income, underfunding, weak resources, and shortage of skilled teachers. But this the major problem identified with the delivery or the attainment of quality education outcomes relates to access to knowledge or access to education materials, which we find mostly pronounced in developing countries. The international level, there are a number of legal and policy instruments that promote the achievement of quality education for all. We have the Universal Declaration of Human Rights, the International Covenant on Economic and Social and Cultural Rights, the African Charter on Human and People's Rights, and then recently the Incheon Declaration for Education 2030. There is also the United Nations Sustainable Goal number 4, which promotes, canvases for quality education for all, inclusive and lifelong learning. When you examine like the Universal Declaration of Human Rights, International Covenant on Economic, Social, and Cultural Rights, as well as the African Charter on Human and People's Rights, you find that these instruments recognize the importance of having the citizenry within a given political society educated in order to also develop their human personality. And we understand that this is necessary because without good quality education, the citizens within that political society are not able to participate effectively in the society. So you might have cases of insecurity or crime rates soaring high because there's underemployment or unemployment or many other societal ills due to no proper human capital development. So far in the course of my research, I've identified copyright as an access barrier. And like I said, the most pertinent issue I identified so far was the access to educational materials. And copyright kind of works as a barrier to this because the economic rights of reproduction, translation, adaptation, rental, communication, they give the holder of the copyrights a sort of monopoly, which makes it costly for persons in certain areas of the world, mostly the Global South, to be able to access these materials at an economic friendly rate. So, for instance, in like my country, Nigeria, we have researchers who need to make use of papers in high quality or high impact journals. So these high impact journals, usually Scopus Index journals, are usually very expensive to access, and so it works as a barrier for the researchers who are trying to access this knowledge goods and create more knowledge. Then you also have students who come from less privileged backgrounds or poor homes and cannot actually afford the costly textbooks. Then there's also the issue of in a country where English is lingua franca, but there are lots of ethnic groups with their different dialects, and so some students are best educated in the language of their locality. And with the major academic texts being published in maybe English, French, or one of the major European languages, you need to scale through some copyright restrictions to be able to publish in this text, and that is one of the issues affecting the access to knowledge. My study argues that the imbalance is sharpest where, like I previously said, where the materials are already hard to afford, like in developing countries like Nigeria. And it's part of my argument that the legal system, especially international copyright system, should be they should tinker with the limitations, existing limitations and exceptions in order to balance private rights with public interest needs. To do this, I relied on two theoretical frameworks: distributive justice and the Marxist theory of law. The distributive justice theory, which was propounded by John Rawls, has two key components. One is the basic system of liberties, which proposes that everyone is entitled to a system of fundamental rights that is compatible with every other person. So you find that, for instance, in documents that envision fundamental rights or fundamental human rights for everyone. So like the Universal Declaration of Human Rights comprises of a number of rights which everyone is expected to have in each political society. So that's like a manifestation of this first principle. And then the second principle has to do with rearranging socioeconomic inequalities in a manner that works to the greatest benefit of the least advantage. And this is the difference principle. And put together, when you put these two principles together and try to apply or transpose to the copyright system, the idea is that the copyright system should be normatively strong or fashioned in such a way that it provides real access to books and other educational materials for the benefit of those from low-income and marginalized communities. I mostly find them in developing countries, mostly in the Global South. Then I also put up the Marxist theory, which tries to analyze the real interests or the interests that are really served by the current copyright system. The Marxist theory, one of the fundamental tenets of it is that law is inherently or intrinsically political, and that law also reflects the ideology or interests of the dominant group. Scholars have argued that the international intellectual property system usually protects the interests of countries in the global north. You have scholars like Ruth Okediji who have pointed out how many countries in the global south we actually not party to the making of conventions like the Berne Convention, because at that point in time they were probably colonies of the major European powers. And then even when you examine the TRIPS agreements, most of the countries seem to have been bullied into joining the trading system and acceding to the TRIPS agreement. So it doesn't really work for the most part to the benefit of the countries domiciled in Global South. I went beyond the copyright system to also argue or to show how the current intellectual property system favors countries in the global north, using examples of misappropriation of traditional cultural knowledge, and traditional cultural expressions. Then there's also reference to the rent-seeking behavior by academic publishing industries, which are usually domiciled again in the global north. The rent-seeking activities basically work to monopolize knowledge, which ordinarily should be distributed more broadly. Beyond the theoretical frameworks, in the course of my research, I've had to examine certain national and regional legal documents, which contain limitations and exceptions, which I find relevant to the intersection of AI and copyright and promoting quality education. So I start with the Berne Convention, which is the foundation of the international copyright system. As we know, it grants authors economic and moral rights, and there's minimum protection of the life of the author plus 50 years. It introduced the three-step test with respect to the right of reproduction, and there are cases where you can, under the Berne Convention, use compulsory licenses. But the major criticism by many scholars is that it is highly author-centric and works against public interest, and then it also restricts national flexibility. Then developing countries have viewed the appendix to the Berne Convention, which gives them some sort of leeway on the translation. They viewed the provisions as highly inadequate, and this has brought about the WIPO Standing Copyright Committee, the works by many countries to try and expand the permissible limitations and exceptions. The TRIPS agreement was also one of the documents which I examined. It incorporates the Berne Convention standards. It extends the three-step test to all exclusive rights. And I got to examine the WTO disputes where the exceptions were analyzed and were basically defined to be interpreted to mean that it would be narrowly defined, not interfere with the normal exploitation of the author's work, and not unreasonably prejudice the right of the holders. But just like the Berne Convention, it has been criticized as reinforcing the interest of countries in the global north. A case in point is the situation with South Africa. I think in 2020, there was a law which the South African government tried to pass on copyrights, and it would have afforded the country greater copyright flexibility. But the US and other copyright stakeholders domiciled in the global north, they applied a lot of pressure, and the South African president, as of then, who is still the president, Cyril Ramaphosa, he withheld his assent to the bill. And so it was an example of using the international copyright system to bully the little guy, or to work against the interest of the smaller countries. So this spurred a group of researchers to try to create like a model law that would or could work for the benefits of those who were not really afforded enough leeway on creating limitations and exceptions that would work to the benefits of their own countries. The next law I examined was the Marrakesh Treaty, which works basically to improve access to published works for blind persons, visually impaired persons, and print-disabled persons. When I went through the law, some things I noticed which were novel, things like cross-border exchange of materials, permission of, it was permissible to circumvent technological protection measures in order to provide access to this list of protected persons. Then NGOs were authorized as entities under the Marrakesh Treaty as people who could actually work towards providing access to published works, either probably through cross-border exchange or changing the format of the work. But the challenges I examined, I was able to notice. One, the burden was mostly placed on NGOs, and existing right holders had limited obligations. And lastly, the three-step test, which has been criticized as being too narrow, was retained in the document. Then there's the WIPO Standing Copyright Committee. So the idea of the Copyright Committee is to develop, overall the purpose behind the committee is to develop modern international copyright exceptions. And there have been proposed reforms in the area of education and research exceptions, digital learning, libraries and archives, cross-border sharing, and a better interpretation of the three-step test. Overall, it works towards a stronger public interest model, because you have various countries from the Global South that propose model provisions that can bring about like an expansive interpretation of the three-step test, and also a better or a much broader copyright flexibility system. I also got to consider the IP protocol, so the AFTA, and what I noticed was for the countries within AFTA, it's the protocol seems to be like the best instrument to use use copyright as a system to develop or rather to promote the attainment of quality education outcome, promote cultural learning, and also promote research. And this is because when you look at the IP protocol, one of the major findings is there is no mention of the three-step test. So it makes no mention of it at all when you go through the protocol. And it recognizes the peculiarity of each country, each African country, and enables them to develop copyright laws as well as limitations and exceptions that suit their peculiarities. But the noticeable flaw or the omission in the IP protocol was the fact that there is very little mention of gender equality, or no attention paid to gender equality in relation to the protocol and promoting the education access. And this is something that Caroline Nkube noted, and I actually found relevant to the idea of the UN SDG 4. The penultimate law which I considered was the InfoSoc directive, which seems to be the most detailed instrument on limitations and exceptions. It supports teaching, scientific research, libraries, museums, archives, and persons with disabilities. It's widely used across the EU member states. Some of the weaknesses, it retains the three-step test, so it's still explicitly or expressly mentions the three-step test. And then the InfoSoc directive respects restrictive covenants or contracts made that affect the use of materials which would otherwise be available for wider use in terms of limitations and exceptions. The last legal provision was the CUSMA, which, unlike the Berne Convention, has the copyright provision for the life of the author plus 70 years. It reaffirms the three-step test. And then in relation to access to knowledge goods or educational materials, there's some leeway for schools and educational institutions in terms of the technological protection measures if they engage in activities that try to bypass technological protection measures for the use of certain permissible uses. They are exempt from criminal sanctions. So the concern, as noted by some authors like Jeremy Dubiez, is that it foist like greater financial burden on students in terms of purchasing textbooks, and that the longer copyright duration increases educational costs. My findings so far, when examining the impact of these regional and international legal instruments on the access to knowledge goods or access to knowledge materials, is that for the most part, there is a greatly imbalanced system which protects the private interest at the expense of public interest, and much needs to be done to bring about like an equilibrium in the copyright system. Perhaps that can be done with the use of AI, but from my preliminary research in relation to AI, I've come to realize that most of the material looks at AI promoting educational quality, quality education through things like intelligent tutoring system, personalized learning, and administrative tasks. So I tried to marry the access to knowledge, AI, and the copyright system, and found the most relevant areas where you can use AI in relation to the copyright system is in terms of academic translation. So like I mentioned at some point in time, in certain developing countries, you have many places where the local language is probably the best way to educate students, and that would be different from the lingua franca. And AI can help easily bring about multilingual education by translating probably this text maybe in something like English or French or Spanish, and a faster and cheaper way, which and also help change the format for the benefit of probably visually and hearing impaired learners. However, there are certain issues with that. One, you require the author's rights, you require the authorization from the author. Well, that can be an issue when probably maybe it's an orphaned work or an anonymous work, and so like those are some issues I'm yet to explore, which in the course of my research I hope to fully dive into and answer. And then there are also issues about where the machine translation errors have occurred, and this in a way infringe views on the author's moral rights, how this particular issue can be remedied. And then when you look at the current scholarship on AI, generative AI and copyright outputs, much of discussion looks at ownership and attribution, and I also want to consider this in the course of the research. There is the argument that AI can bring about the provision of e-textbooks and help in the provision of digital libraries. Post-COVID, some South African libraries were identified as having provided AI-enabled digital library services. But as anyone would note, there would be issues about maybe circumvention of technological protection measures, and then the alteration of rights management information, which would go against provisions like the WIPO Copyright Treaty and existing national laws. And so this so far constitutes much of what I have considered in the course of my research. I'm still looking to expand beyond this to consider things like text and data mining and other areas where I believe AI and copyright can intersect and have like an impact on the achievement of quality educational outcomes in developing countries. I think with this, I have come to the conclusion of my presentation.
Thank you very much, Mr. Oshobugie. You were right on time. I had just typed that you have 2 minutes left, and you actually did not even use that. Okay, we invite the first discussant now, Dr. Felipe Romero Moreno.
Oshobugie, that this is a very highly and relevant, timely presentation. In fact, your approach contrasting AI-based educational initiatives in developing countries with the limitations of the current international copyright regime provides a clear and compelling lens for examining the structural challenges of Sustainable Development Goal 4, that, as most of you are aware, is a global commitment that seeks to ensure inclusive and equitable quality regarding both education, but also promoting lifelong learning opportunities. Having heard your presentation, I particularly agree with your argument that the rigidity you mentioned existing copyright frameworks, specifically the lack of clear text and data mining exemptions, disproportionately impact the ability of developing nations to use AI, in particular to improve educational access. So, focusing on balancing rights and student protection, you discuss the benefits of AI in education. You mentioned, for instance, personalized learning and accessibility. However, as you might be aware, there is concern that using foreign own AI platforms, so think, I don't know, ChatGPT, Copilot, Gemini, Claude, and the likes, using these AI platforms might lead to the exploitation of local student data. So my question to you would be, how can a country promote AI innovation in its schools or, say, universities, while also ensuring that the student data is protected when it comes to, say, privacy, data protection, etc.?
Okay, I think you will answer at the end. Have that question written down and ready to get answered by your first discussant. Our second discussant, Dr. Ge Chen, Associate Professor in Global Media and Information Law at Durham Law School. You have the floor. Thank you.
Thank you. So many thanks for this engaging presentation. I actually did some work on this many years ago. I found it quite valuable that you could bring together 3 areas that are often discussed separately, like AI, now IP, and the right to education. I think the focus on developing countries also gives the project quite clear practical significance. I think I've got 3 questions or comments, whatever, to make while you speak. First, I think through the presentation, copyright is presented largely as a kind of constraint on educational access, especially in developing countries. I was wondering whether this picture might be somewhat more balanced in your project, because copyright also provides incentives for the creation of educational materials or digital learning resources, right? And sometimes also AI-related educational technology. So how would you envisage balancing these competing interests? That would be my first comment or question. I think secondly, I was interested in your comparative methodology, of course. You mentioned Canada, Nigeria, Kenya, perhaps as different jurisdictions. Could you perhaps say a little bit about why these countries were particularly selected, what kind of comparative insights you may expect this combination to generate. Now, finally, I've got a final point that struck me is that many of today's debates actually remind us of earlier international copyright negotiations, right? Because historically, I think international copyright law has struggled to balance the incentive for creativity with or against access to knowledge itself. For example, the UCC, right? It's a long history. The Universal Copyright Convention, I was saying, in 1952, was often viewed as giving us a more accessible framework for developing countries, right? Than the Berne Convention itself. And later, the 1967 Stockholm Protocol to the Berne Convention attempted to introduce some access to copyrighted works for developing countries as well, through mechanisms such as compulsory license. These reforms, of course, achieved very limited success because they only reflected an earlier international kind of efforts to reconcile the copyright protection with access to knowledge. So I was wondering whether engaging with this kind of historical development might enrich your argument. Do you see today's debates about AI, copyright, and educational access as fundamentally new or as the latest chapter in a much longer debate about balancing incentives for creators against access to knowledge in developing countries? Because we know there has even, I think 10 years ago at least, there was a monograph published by Hart, probably, right, about copyright in developing countries already. So I was wondering what your point would be. I think I'll stop there.
Okay, thank you so much, Dr. Chen. We will now go on to the pair commentators. Can we have Yi-Hen Lu, please, for your comments?
Yes, it's an excellent topic, and we never think about that before. So I really appreciate that I have this opportunity to come here and make this peer reviews. So it's kind of interesting, like for us, like if we are discussing about like AIs or any part of like maybe I'm researching about copyright. So if we discuss about AI or copyright, and generally we will discuss about like China, US, EU, or the UK. So this is generally what we are going to do around the jurisdictions, but we never like have the angles or have the perspective to look at like Nigerians or have the perspective of Africans. I have some like I have some of my like colleagues. They are doing some research around like maybe the performance right around like Africa. So we have some research around Nigerians, but never through an angles of AI. So I think it's very promising to look at this at a specific like a special angles to look at the AIs and also the educations, and it will show the different like what shows the different spark for us. And personally, I think it's very promising. Yeah, thank you very much.
Thank you. Okay, so you're back on the hot chair. I hope you have all your answers ready, Mr. Oshobugie. You could start with the first question from our first discussant. I can't see any questions on the chat, but if you have any questions, if all the attendees, you can put some questions on the chat or use the raise hand function to ask further questions. Sorry for interrupting, Mr. Rebat. You can go on.
So I think for the first question, which is related to Felipe Romero Moreno's question, is how can a country protect its data for students when the AI models are being owned by foreign organizations. I think that's how I summarize it. I don't know if I got it. Yes. So I think for that aspect, I think that has to do with majorly data privacy and data protection laws. There are, I know at the EU, they have the GDPR, which has like stringent data privacy protections for organizations that have to deal with data where the data subjects are domiciled in the EU. And so I think likewise, there are like that is like a precedent countries can follow. I'm not well versed in the area of data privacy, but I think that is something maybe like a country like Nigeria or Kenya can seem to adopt and use in terms of protecting the interests of the students whose data would obviously be harvested or rather be used or be processed. Be lawfully processed by like a data controller outside its jurisdiction.
So that's perfect. And yeah, I would agree that we need some kind of a legal framework, and particularly the EU GDPR, I think, is the strongest, and it can serve like a blueprint when it comes to striking a balance. On the one hand, intellectual property, particularly copyright protection, and on the other, for example, internet users' right to personal data, data protection, and so on. Thank you.
Thank you. I'm sorry if I don't pronounce it well, Ge Chen. I think so. I got the first question. Copyright I majorly presented copyright as a restraint or as like a restrictive instrument. Well, how do I balance this with the positives? So I know when we trace the origin of copyright to the Statute of Anne, and see the idea behind the promotion of public learning, having books in circulation. Yes, we should appreciate the importance of copyright in terms of promoting public learning and promoting works. And in the course, it was omitted from here, but in the course of my research, I actually acknowledged this in the English and also in the American legal system, because I know it does form a part of the American Constitution, where you have copyright protection being granted to authors for the lifetime of their lifetime and certain period afterwards. And it is with the idea of promoting arts and useful learning. So I think this is something I haven't examined within the local perspective, and what I mean within local, like within the Nigerian and the Kenyan perspective, to see how it has really been a benefit. But I have actually examined it within the US and the UK system and recognized that copyright actually worked as a tool to promote learning, and I would apply this suggestion to properly or bring about like a proper balance, if I might say. Moving on to your second question, the rationale for choosing these countries. So Nigeria, firstly, I'm Nigerian, and I was looking at this problem from a Nigerian perspective, and I thought with the introduction of the Copyright Law 2022, Copyright Act Nigeria 2022, I'm looking at the some of the novel provisions, such as the mixed fair use, fair dealing provision. I thought, okay, this is probably something I need to consider, see how the law, the AI, and the other systems in place work to promote quality education outcome. We have in Nigeria, I think, a digital transformation strategy that recognizes the utility of AI in achieving certain national objectives, one of which is literacy. Canada has, from my understanding of the Canadian copyright perspective, has a very liberal approach. That's copyright approach in the promotion of education objectives. So there's this case. I think there are a few. I doesn't come to mind now, but I know there are like two cases where the Supreme Court of Canada has interpreted its limitation and exception provision as being something not strict and flexible, and so I considered that this might be helpful in recognizing the way or like the importance of using copyright to achieve the education objectives. Kenya, I chose Kenya because like Nigeria, it has like a similar legal system and similar copyright laws, and much of its copyright work or laws is the legal and the policy side is geared towards achieving a greater rate of, like say, quality education within its jurisdiction. I know for a fact there's the Center of Intellectual Property and Technology, and I was studying some of its works and realized this might actually be a good place to get materials and then compare and realize, or rather like achieve like a broader understanding of where I'm going with my thesis in mind. I don't know if this answered the second question. The third one, the reforms, I think has to do with, do I see the debate on AI copyright and access as relevant to the historical debate on copyright reforms? That was what I got down as the third question. Yes, I see it as relevant because I think from the historical debates, what I was able to get from some of the texts I read was there has always been a debate on how to make copyright serve the interest of like the public, how to make copyright serve the public interest. And with the introduction of emerging technologies like AI right now, it seems to be just like the same debates, just or the same issue, just the different way. So I think yes, it's relevant, and thank you for bringing that over, because I will have to go look at the wider historical background to probably buttress this buttress my argument on this aspect about falsifying or rather widening copyright widening the copyright flexibilities are available to promote public interest goals.
I think you did brilliantly well. So kudos to you. On the first point on data protection on Nigeria, you may want, if you want to add to your research, you can look at the transition Nigeria has had from the NDPR, that's the Nigerian Data Protection Regulation, to the Nigerian Data Protection Act. And we do have a Data Protection Commission in charge of data of everybody, which includes what the first discussant, Mr. Felipe Romero Moreno, mentioned. So it's something that you can have a look at. Thank you very much, Mr. Oshobugie, for an engaging and thought-provoking presentation. Your research addresses an important and timely question, which all the discussants have also acknowledged, of how intellectual property rights can either facilitate or constrain access to AI-driven learning technologies in developing countries. The presentation has highlighted the need to move beyond a purely innovation-centered understanding of intellectual property and to consider more carefully its implications for educational access, affordability, technological dependency, and equality. I would also like to thank our two discussants, Dr. Felipe Romero Moreno and Dr. Ge Chen, for their insightful and constructive observations. Their comments have helped deepen the discussion by drawing attention to the wider regulatory, human rights, copyright, and public interest dimension of the research. My thanks also go to our peer commentator, Yiheng Lu, for offering a valuable interdisciplinary perspective and for identifying important questions that may assist Mr. Oshobugie in further refining the conceptual framework and arguments of the project. We are equally grateful to everyone who has attended the session. On behalf of the Globalsouth Network, I would like to thank all our speakers, discussants, commentators, and participants for their time and generous engagement. This then concludes the 26th seminar of Phase 5 of the Globalsouth Network International Interdisciplinary PhD in Progress Seminar Series. Thank you once again, and I wish you all a very pleasant afternoon.